Welcome back to Law and Crime's live coverage of the trial of Kellen Winslow II, the former NFL player who played a number of seasons, but who now finds himself seated in a courtroom facing sex crimes charges involving 5 women aged 17 to 77. Let's listen in as the defense gives its closing argument. We're listening to the prosecution rebuttal in the case against Kellen Winslow II in California. He faces 12 counts, most of them sex crimes. The alleged victims aged 17 to 77. Ecleynne Mercy is with me here on the Law and Crime Network right now. She's a defense attorney in Atlanta, Georgia. So Ecleynne, we're listening to the rebuttal here from the state, and they're basically just saying, look, the defense can't sit here and say all 5 of these people are mistaken. Okay, maybe there's a couple of inconsistencies here and there. Maybe some memories are fuzzy, but when you line them all up together, they all have similar enough stories to be believed.
Yes, and they've had years and some time to get their stories conveniently related. The issue is that we have a whole lot of, he did discuss the difference between direct evidence and circumstantial evidence. And he did talk about direct evidence being the testimony. But unfortunately, that's all we have. What they did is Mark Carlos did an excellent job of just really laying down that all they have is 5. At this point, the state has 5 alleged victims and who have 5 different stories that they're picking and choosing that makes it congruent. You understand? Like rape is a crime, and it has the same. I mean, it has the same actors. It has the same transactions. We can change a little bit, but at the end of the day, it's going to be the same type of story. So Mark Carlos just basically brought out the prosecution's, the prosecution's handbook, which is to say, hey, we have 5 people, the consistent of 5. They just did according to the defense, it's like they just took all of it. It was like a BOGO. You try one, get all 5 for free. And I think that's what the prosecutor did. And Mark Carlos did an excellent job of just providing that to the jury.
Saying they can't do it that way. Look, we're going to take a break. We'll be back with more after this. And the judge now giving the jury the final charge to basically begin deliberations in the case against Kellen Winslow II. Again, this is a sex crimes case in California, 12 separate counts involving 5 women who are accusers. The youngest was 17 when she said she was attacked. That was Jane Doe number 4. The oldest, Jane Doe number 5, 77, says that she witnessed some perverse behavior inside a Crunch fitness center while the defendant was out on bail waiting for trial with regards to all the other accusations. Would he really do that? The defense saying no, the state saying yes, because he's a sexual deviant. Ecleynne Mercy is an attorney in Atlanta, Georgia. She's with us tonight here on Law and Crime. So, Ecleynne, generally speaking, how do you think the state did there on the rebuttal?
I think that they hit all the points that they should have. However, I think they gave a lot more. They actually helped the defense a little bit in really clearing up the defense's part, which is saying that, hey, the testimony, that's all they have. And he just referred to the testimony and didn't provide any DNA, didn't provide any videos, didn't provide anything else but the testimony. Like, hey, we have to believe him. We have to believe these women because they're a lot.
Okay, so look, long ago, long gone, I should say, are the days when you have to have corroborating evidence to basically back up an accusation of a sex crime. So is that necessarily where the law sits?
No, I think the issue is that the veracity of the statement, or how much we put into a statement, actually goes to the timing as well. It's unfortunate. Now we have laws that say with certain sex crimes that there is no statute of limitations. However, what that does is we don't have enough evidence. And although, yes, testimony is a direct evidence, but the burden of proof being beyond a reasonable doubt, and how every single alleged victim in this case has some issues with their testimony, has some issues with identification, has some issues with the evidence. So I think that's going to be a tough thing to battle.
Well, look, if they had tried these cases separately, it would be tough, but trying them all together may give prosecutors a win here. At least that's the way I see it. Bottom line, we're going to take a break here on the Law and Crime Network. We will be monitoring, however, the deliberations as they unfold into the afternoon in California, into the evening here on the East Coast. We will be back after this.